Welcome to Case by Case. This is a podcast brought to you by ZFZ. Today you've got Luke Zadkovich and Eva-Maria Mayer on the pod. We're missing Callan Shane, who's off running around the world, doing his meetings and what have you, but very busy this week. So excited that you could join us, Eva. Happy to have you on the podcast.
Happy to be here. Thank you very much for the invite.
So for those of you that don't know Eva is one of our senior associates in our New York office, which has got a broad array of experience in law, commercial law, arbitration work, shipping, of course, commodities, and we handle a lot of arbitration cases together, and today's case is in the arbitration space.
We have a good case for you coming out of the Second Circuit. It was a case of first instance for the Second Circuit, in fact. Some good analysis in there, I think. I'm happy to talk to you about it.
Yeah,
Did you want me to go ahead with the background facts, or maybe we should introduce the name of the case first?
Yeah, exactly. Let me do that first, but that would be great if you could kind of give a factual summary for our listeners. And thank you, everyone, for listening in today. So what we're talking about, the Smarter Tools, Inc. and, I'm not sure about how to say this, Chongqing SENCI import and export trade case. This has done a little bit of yo-yoing up and down from arbitration to court, back to arbitration, and then into court, and then appealed again in court. So it's got a bit of a checkered history, and we're going to go through that in some detail. The citation for the case is 57 F 4th 372. That's a 2023 decision decided on January 17, 2023. So relatively new, only a few months old. And it gives us a really good platform to look at what happens when an arbitrator does not give a fully reasoned award. What should the courts do if that award is challenged, as it was in this case? That's what we're looking at, it's quite an interesting one. I think it throws up some good discussion points here. So looking forward to getting into it with you. Let's get into the facts. Hey, would you like to kick us off?
Yes, happy to. It's like I said, it's a case of first impression, where a buyer of gas-powered inverter generators for resale, Smarter Tools, Inc., brought an action against the suppliers of those generators. I'm just going to refer to them as SENCI to keep things easy here. To get back into the original facts, Smarter Tools is a corporation that buys and resells tools and also these power products. SENCI, which consists of two corporations, make and sell these gas-powered generators. From 2011 through 2013, Smarter Tools entered into several contracts with SENCI to purchase about 17,000 of these gas-powered inverter generators for the price of about $6 million. What's of importance here is that SENCI produces several types of the gas-powered inverter generators that Smarter Tools bought. One that is certified by the EPA, but not by the California Air Resources Board, or CARB for short. So that one can only be sold in every U.S. state except for California. Then there is also a version that is both EPA and CARB certified, and that one can be sold in every U.S. state, including California. Now, I'm sure that's a bit of foreshadowing right there. But a dispute between the parties arose about whether these generators that Smarter Tools ordered were supposed to be CARB compliant. That dispute arose because Smarter Tools was fined about $500,000 for selling non-CARB compliant generators in California. And that is because the generators that it received from SENCI were in fact not CARB compliant. Obviously, that resulted in quite the breakdown of the relationships between the parties. And pretty much the only positive aspect here is that neither party disputed that Smarter Tools owed SENCI around $2.5 million for generators for which it had received, but it had not yet paid.
Right. So then what happened is the contracts provided for arbitration to resolve disputes. The matter gets referred off to the AAA, the American Arbitration Association, for arbitration under those rules in New York. And actually, Eva and I are handling a AAA arbitration at the moment in a completely unrelated case. So we know this procedure quite well and have been talking about it only over the last few days. Anyway, that's kind of by the by. But this matter was off to AAA arbitration, went through the process. The arbitrator ultimately found that STI did in fact owe SENCI the $2.4 million and issued an award in favour of SENCI, the suppliers. Now, the award didn't, I think it's fair to say, give a lot of detail in the reasons for finding in SENCI's favour. And some of the areas where the reasoning was not developed related to testimony. And the arbitrator made some statements about, well, having heard the testimony, I'm not convinced by it, words to that effect, and I prefer SENCI's position over STI's position. And not much more than that, frankly. It was almost like, I've heard the evidence, I've heard the testimony, and I prefer this evidence, and so I'm going to go this direction, without an explanation for why the arbitrator prefers this testimony over that testimony, or what were the problems with the testimony in some detail. So it was quite a short way of handling what had been quite detailed testimony given by the parties.
It must have been a pretty disappointing day for the parties when, well, one happy, the other sad, but not quite sure why. Just know that they are.
Exactly, you're right. You spend so much time, as we know, don't we, where you pour your heart and soul into putting together proofs of evidence and cross-examining the other side and all of this. So you kind of want to know. I think even if you're on the winning side, you want to know why you won. Anyway, but in any event, the award wasn't detailed. So STI then challenges the award, and so for everyone listening in, I know we've got a large listenership in England. This is over in the US. We don't have the concept of an appeal of a point of law in the US. We have challenges. So, seeking vacation or vacata of the award. And the thresholds for seeking vacata of award are quite high. And here, STI challenged the award, arguing a number of reasons why it should be vacated. That effectively that the law was manifestly disregarded, and that the award was not reasoned. So we now are up into court. The first instance court, looking at the original award, agrees with STI and says this is not a well-reasoned award, and particularly on the reasoning relating to the substantive merits of the decision. There was very little on that at all. But the award was clear in the decision that it made. And I think that's a critical part of this. It wasn't like the arbitrator was unsure which direction to go. The arbitrator was very clear in the decision it made, but didn't give much by way of reasoning. And that first instance court agreed with STI, said that the award was not well reasoned, and then this is the controversial part and what this whole decision is about, sends the award back to the arbitrator to give more reasons. And I think of this as like the second bite of the cherry. I think this one should be called the second bite of the arbitral cherry or something like that. Because the arbitrator then has the opportunity to give reasons for the award, naturally in keeping with the original decision, but fleshing it out. The arbitrator then gives this detailed award and it bounces back up to the court. STI aren't happy. Obviously, the decision hasn't changed for them. They then appeal it back up to the court, and they want to argue that the original court was wrong and erred when sending the original award back to the arbitrator to give more reasons, rather than just vacating the award there and then. And there were some reasons for that. And that's where we are. We've then kind of gone back through another appeal court to get to this decision on this question of whether the original court should have sent the matter back to the arbitrator for more reasons.
And I think an important point to note here is something that at least this court, the Second Circuit, notes, is that the parties specifically agreed that the arbitrator should issue a reasoned award. So not only was there not a reasoned award, but it was a specific agreement between the parties that there would be a reasoned award, and now there was not.
Yeah, exactly.
No, I just wanted to start talking about the points that Smarter Tools raised, or as to why this has all gone awry, and really the arbitration award should have been vacated from the start. It makes a couple of points there. Luke, you've already mentioned them. Is essentially, and then they provide a very fancy Latin name for one of the doctrines, functus officio, saying that the doctrine of functus officio and the FAA, the Federal Arbitration Act of the U.S., bars the district court that previously decided to send the award back to the arbitrator for further details, and that the amended award was still not reasoned. Then the court just goes through those three main topics to come to its final decision.
Before getting into the reasons for the court's decision, I think the starting point here, and one of, and we've kind of alluded to this already, but one of the important factors to keep in mind is that the party moving to vacate an award in the US system, and indeed in any system in the challenge scenario, which is different to the appeal scenario, as I said, has a high burden. It's described here as a heavy burden of showing that the award falls within a very narrow set of circumstances delineated by statute and case law. And the reason for that is that the courts now, in this day and age, and I say this day and age because it wasn't always the case. Go back 30, 40, 50 years ago, courts had a different view of arbitration and may have seen it more as a challenge to the original jurisdiction of a court. These days, courts in the US and most courts around the world are very pro-arbitration, and they seek to encourage the support and support the use of arbitration. And that's for efficiency, that's consent of the parties, that's so courts aren't overburdened. Often arbitration is between sophisticated commercial parties that want privacy and confidentiality over their disputes. So there's a host of reasons why arbitration is promoted. But that's the perspective, or that's the kind of approach that the courts are taking. And also to avoid kind of protracted litigation and this going on and on and on of relitigating issues. Courts want to try and bring them to an end. And I think just kind of one of my impressions of this decision is that overriding principle, if you like, or that approach has guided the court. And there's specific reasons for the decision that we'll mention in a moment, but that overarching principle, I think, is very important here. And it goes to this point. Well, look, the arbitrator made a decision. The courts agreed on arbitration. They agreed on the process. The process was followed. The arbitrator decided how the dispute would be resolved in a clear way. The form of that decision wasn't good enough. The way that the arbitrator explained how it got to the decision wasn't good enough. But that's not necessarily a reason to undermine the actual decision that the arbitrator made.
That's right. Yep, I completely agree with that. I think this decision screams that. Multiple times the court refers back to this of, really under only the most narrow and extreme circumstances can we step in and actually vacate an award. It is not our job. We are here to enforce, if anything, a contractual agreement between two parties to arbitrate these disputes. There are specific exceptions, of course, where an arbitrator oversteps those powers, where all of a sudden an arbitrator is deciding the merits on a case of a party that's not party to this arbitration agreement. And that is something that this court also refers to, that at that point, yes, there is merit for a court to step in and vacate an award. But there are narrow grounds, and specifically the Second Circuit states that they have applied those narrow grounds very narrowly. And so that is their perspective. That's how they are approaching this. And like you said just now, Luke, it's an issue of style of how the award was portrayed. It was not a question of the ultimate outcome that the arbitrator had in the award. Yeah,
exactly. And if we go to the doctrine that you've mentioned, the Functus Officio doctrine, what's that all about? Well, that's all about the arbitrator's jurisdiction concluding once an award has been issued and the merits have been decided and there's no more issues to be dealt with. And the reason for that doctrine, or one of the reasons for that doctrine, is so that arbitrators are not influenced after coming to their decision in some inappropriate way. And so there needs to be this kind of drawing a line in the sand. Well, that's it. The award has been issued. The jurisdiction of the arbitration tribunal now falls away, and they made their decision. He or her, they made their decision, and that's that. That's the Functus Officio doctrine. Now, there are exceptions to the doctrine, and that's what this decision explores. And some of those exceptions relate to where there's some ambiguity in the award, and parties are able to seek clarification of certain points. So that's not a reconsideration of an issue that has been decided. That's a point of clarification. Where there's an obvious mistake on the award, that could be another ground for when this doctrine of Functus Officio doesn't apply and there's an exception to it. When the award doesn't deal with an issue that was submitted to it, it just is absent. Well, the award and the arbitrator almost hasn't kind of completed its jurisdiction with respect to that issue. That's another exception. And that the other point that I mentioned before, this question of ambiguity. And so that there are these exceptions to that doctrine, which I think, as you say, Eva, they all go to a question of form and a question of kind of trying to understand what the actual decision already is of the arbitrator, not to relitigate it, not to go back over it, not to put new points to the arbitrator to get to a different decision, but they're more aimed at understanding what the arbitrator has originally decided. And it's kind of like in that category. The question here is, in a situation where an arbitrator doesn't give full reasons for the award, does that fit into this kind of form over substance type genre or area, or no? Is the failure to issue full reasons and properly explain the award something so fundamental that the award itself should be vacated and set aside? Is it in that kind of more substantive category?
Yeah, it's very interesting. And I think that the point that was earlier brought up about, well, the parties actually agreed that there would be a reasoned award. So I think there could almost be an argument, and this would ultimately go against the finding of this court, but there could be an argument that that was actually a fundamental part that was the arbitrator's job to fulfill. That was something that was in his powers, that he didn't address this part. He didn't participate in the arbitration in the way that he was asked to. And therefore, maybe that's actually an argument against how the court found here, saying, no, this actually goes to the fundamental assessment of this case, is providing a reasoned award, and you didn't do that. And therefore, this entire, reason why we have you around, Mr. Arbitrator, is no longer there. I'm assuming that, Smarter Tools had an argument along those lines. But yeah, not the case here. The court ultimately found that this was a question of format, not substance. And it makes sense ultimately, especially because Smarter Tools ultimately also makes a claim for disregard of the law. Well, if there is no reasoning in the award, it's pretty much impossible for any court to assess whether or not there was a disregard of the law if it is not provided. So I could see it almost also being a tool and a necessity for any court that is being asked to rule to vacate an award to actually have some substance in thinking of the arbitrator behind that award.
I agree with you. I agree with you. I'll come back to your other point. I think it's a really good one about what the parties actually agreed they required here of the arbitrator. But just on that manifest disregard of the law point, I think, again, you've got to go back to kind of first principles of what guides the court in considering these types of issues. And the court emphasised here that an award should be enforced, even despite the court's disagreement with it on its merits, if there is a barely colourable justification for the outcome reached. So it's this concept of barely colourable justification. The arbitrator only has to get into that category, that realm of barely colourable justification. And even if the court has a different view, the court will enforce that award. And so there has to be something quite significant to take an award and an arbitrator's decision outside of that and ask the court to kind of overturn it on its merits. So that really didn't get much play. And the court looked at this largely through Sections 10 and 11 of the FAA, the Federal Arbitration Act in the US, and found that this was not a Section 10 case, and it didn't necessarily require vacation of the award or vacator of the award. And instead, they came to the view that the failure to provide a reasoned award is something that best fits within Section 11 of the FAA. And that allows a court to make an order modifying or correcting the award where the award is imperfect in a matter of form, not affecting the merits of the controversy. And that does seem on point because, as we said at the outset, the arbitrator has made a decision on the merits. The arbitrator is clear on the merits. That's not the issue. The issue is one of how the arbitrator expressed that view. And that does seem to be a question of imperfection as to form rather than merits. When looked at, particularly through the language of the FAA and what sets up the party's ability to seek vacator of an award. But coming back to your point, and that is, did the parties actually expressly agree to requiring something higher than what would have been required under the AAA, given that the AAA rules were incorporated, or indeed as a matter of law under the FAA? By saying we require a reasoned award from this arbitrator and that's part of the express arbitration agreement. And the failure of the arbitrator to do that, does that kind of go in some way to the original jurisdiction of the arbitrator, a failure to, I don't know, perform the arbitration agreement in some way? And I don't think that really I think it was argued. I don't think it got much ventilation in the decision. I think the court looked at it through the prism of the FAA and Section 11 in particular. But I think it's an interesting discussion point you raised there, Eva.
The court was looking, the way that I read it is that the court was looking for guidance as to how to address this point. And it cited some cases from the district court, Southern District of New York, as well as Sixth Circuit decisions, which found the way that the Second Circuit ended up finding, saying that this is a form issue, not a substance issue. It was unable to, or it did not at least, cite cases that were exactly on point. So I do think it's an open question, and if we ever get to argue it, might be fun. But yeah, there's something to be said for this express, I think, agreement for a substantive award with an explanation by the arbitrator.
You've put a finger on, for not the first time in our discussions, Eva, a finger on the key issue in dispute, and really where the rub of this case is. And I don't think that got as much ventilation as it should in some ways. So I think it's a good point. Whether that was enough to carry the day, I'm not so sure. I tend to think this is the right decision overall, but it's an interesting one. Thank you, everyone, for listening in, and we hope you've enjoyed this discussion today, getting into some arbitration law and how challenges are dealt with, particularly in this instance when an arbitrator does not give full reasons for the award. Should the arbitrator have a second bite of the arbitral award cherry or not? Should it be vacated? And that's it, done. Failed to perform duties and the award is vacated. If you've got any thoughts on it, let us know. Drop us a line, make some comments on social and what have you. But thank you for listening in. We hope you've enjoyed the discussion. Eva, thank you to you. Thank you for stepping in today. It's always a pleasure having you on the podcast. And yeah.
Thanks for having me.
Take care,
Look forward
everyone.
for your next overdue.